Can we have a round of applause? It is my absolute pleasure and honor to welcome you all to the Indian Council of Arbitration session titled ADR Tapestry, Weaving a Resilient Arbitration and Mediation Ecosystem in India. The theme under discussion today serves as a litmus test for our collective aspirations in realizing the national vision of positioning India as the global hub of arbitration and increasingly mediation. As we engage in today's deliberations under the guiding light of Honorable Mr. Justice Prashant Kumar Mishra, Judge, Supreme Court of India, we are prompted to reflect critically: has the policy and judicial stewardship of recent years truly nurtured the cause of a robust ADR landscape in India? The dialogue ahead offers not just a moment of reflection, but a chance to reimagine, recommit, and reinvigorate the future of dispute resolution in the new India. As we host you today, it is a matter of great pride to reflect on the Indian Council of Arbitration's journey of over 60 years in institutional arbitration. The ICA has consistently remained at the forefront of promoting ADR as the preferred mode of dispute resolution, both within India and on the global stage. We now move to this felicitation of our chief guest today, Honorable Mr. Justice Prashant Kumar Mishra, Judge, Supreme Court of India. I request Dr. N.G. Khaitan to kindly felicitate Justice Mishra with a green certificate. This certificate serves as a pledge as we plant trees in honor of our esteemed dignitaries. Thank you, sirs. To set the tone for the session, I would invite Mr. Arun Chawla, Director General of ICA and former Director General of FICCI, to address the gathering.
Honorable Justice P.K. Mishra, Judge, Supreme Court of India, Mr. N.G. Khaitan, President, Indian Council of Arbitration, distinguished panelists, esteemed members of the legal fraternity, industry experts, a very warm welcome to all of you to this IC session on ADR under the umbrella of Delhi Arbitration Weekend 2025. Truly delighted by this overwhelming response. It's a testimony to the eagerness amongst the audience to listen to the visionary statement of our chief guest, Honorable Justice P.K. Mishra, someone who has had an illustrious career, having co-authored landmark judgments spanning a wide spectrum of legal domains, from commercial and environmental matters to constitutional and criminal law. His comprehensive engagements lend his perspectives rare depth and width, making it specially relevant to today's discourse on building a resilient arbitration and mediation ecosystem in India. So please join me in giving him a warm welcome. Ladies and gentlemen, we have a galaxy of eminent panelists who will enrich the roundtable by their valuable remarks. Of course, greatly honored by the presence of Honorable Justice Jasmeet Singh, Delhi High Court, whose consent to participate shows the importance the judiciary is attaching to ADR. Today's deliberations reflect on shared aspiration to craft a robust and future-ready ecosystem for arbitration and mediation in India. As our nation progresses towards the clarion call given by its leadership to make India the hub for global arbitration, and more recently, even mediation, it becomes imperative to assess both our systemic strengths and, of course, challenges. Every segment of dispute resolution landscape must be aligned to promote ADR mechanism in India. This alignment is not merely desirable, it is the pressing need of the hour, especially in the light of the staggering backlog of cases burdening the judiciary. The scale of judicial pendency has now been acknowledged from within the system itself, and the recent decision by the Honorable Supreme Court to dedicate an entire quarter to the Mediation for the Nation campaign in collaboration with NALSA is a compelling reflection of judicial intent. It signals a conscious effort to divert civil commercial disputes away from traditional courtrooms, thus enabling the courts to focus on core constitutional and criminal matters. Ladies and gentlemen, even on the mediation front, while the canvas may still be evolving, the judiciary has steadily painted a clear intent. Though pre-litigation mediation remains underutilized, key judgments such as Patel, Automation and Yamini Manohar judgments have reaffirmed the judicial nudge towards respecting the mandatory pre-institution mediation mandated under the Commercial Courts Act 2015. These decisions, juxtaposed to legislative recontouring of the relevant laws, are shaping a culture where parties are encouraged and increasingly expected to resolve disputes outside of traditional courtrooms. Our gratitude also extends to the representatives from the DAW Organizing Committee, other key stakeholders who have joined us today, making this dialogue truly comprehensive and inclusive. Ladies and gentlemen, we look forward to an insightful and engaging evening ahead. Let us do so with awareness that ADR in India is not in its infancy, but at a defining moment. The journey ahead lies not in simply adding more threads, but in weaving them together deliberately into a cohesive, resilient, and enduring ADR tapestry. With that, it is my honor to welcome you once again, and I invite the President of ICA, Dr. N.G. Khetan, to deliver his special address. Thank you.
Namaste, Subh Sandhya, and good evening to you all. आज मैं कुछ हिंदी में बोलूँगा, कुछ अंग्रेजी में बोलूँगा, बिकॉज ये मेरी आदत है. आज हमारे समक्ष सुप्रीम कोर्ट के जज श्री प्रशांत जी मिश्रा यहाँ पर उपस्थित हैं. ये कुछ मैंने जब भी कोई सुप्रीम कोर्ट के जज बनते हैं तो उनकी बायोडाटा लिया जाता है. मैंने इनका बायोडाटा देखा तो एक रेयर है इनके बायोडाटा में कि ये स्टेट के एडिशनल एडवोकेट जनरल भी रह चुके हैं, स्टेट के एडवोकेट जनरल भी रह चुके हैं, चेयरमैन ऑफ द बार काउंसिल भी रह चुके हैं, और कोलिजियम ने इनका नाम रिकमेंड किया था सुप्रीम कोर्ट के लिए, एंड उसका अप्रूवल 2 दिन के अंदर हो गया. सो दैट इटसेल्फ इज ए हिस्ट्री. इट्स क्रिएट दैट ही वाज रिकमेंडेड बाय द central government, the ministry of, within 2 days his name was recommended as a judge of the Supreme Court. आज हमारे समक्ष दिल्ली हाई कोर्ट के जज श्री जसमीत जी सहाय हैं। हमारे मंच में पिंकी जी आनंद जो एडिशनल सॉलिसिटर जनरल रह चुकी हैं, गीता जी लूथरा हैं जो हमारे वाइस प्रेसिडेंट हैं, पंकज जी चौधरी हैं, मोहित जी सराफ हैं। इन्होंने आज मेरे को कहा कि खेतान जी आप थोड़ा सा इस बार आज फ्रैंकली कुछ बोलिएगा, डरिएगा मत, बिकॉज यू विल बी इन फ्रंट ऑफ ए सुप्रीम कोर्ट जज। तो मैं कुछ साहस करूँगा कुछ बोलने का, मे बी आई ट्राई टू स्पीक। बोले आप, हम बोले जब मंत्री रहते हैं तो कुछ हम लोग को संभल संभल के बोलना पड़ता है। so, हमारे खुद ऑफिस के कोलीग्स संजीव जी कपूर हैं, मिस्टर घियावत हैं, मिस्टर ठाकुर हैं। आज हमारे मॉर्निंग में फैकल्टी कुछ इन्होंने ज्ञान दिया था, गणेश जी चंद्रू ने, तो आज गणेश जी भी हैं यहाँ पर और वीर राघवन जी भी हैं। तो सबों को बहुत बहुत धन्यवाद कि आप लोग सब पधारे यहाँ। सर, हमारे प्रधानमंत्री ने कहा था कि वी मस्ट मेक इंडिया एज ए हब ऑफ इंटरनेशनल आर्बिट्रेशन। तो आईसीए के तरफ से इसका हमेशा प्रयास रहा है। और आपकी जानकारी के लिए केवल ये बता दूं कि पिछले 10 महीनों में हम लोगों ने अपार्ट फ्रॉम हैविंग कॉन्फ्रेंसेस इन इंडिया 4 इंटरनेशनल कॉन्फ्रेंसेस किए। एक इंटरनेशनल कॉन्फ्रेंस हम लोगों ने नवंबर में सिडनी में किया, जो fortunately we had an opportunity to have a parliament to speak at the parliament in Sydney, और हमारे जयशंकर जी एक्सटर्नल अफेयर्स मिनिस्टर थे वहाँ। उसके बाद सेकेंड कॉन्फ्रेंस हम लोगों ने रियाद में किया, सऊदी अरेबिया में, जहाँ पर हमारे साथ हमारे लॉ मिनिस्टर और अटॉर्नी जनरल ऑफ इंडिया थे, पिंकी जी भी थी। फिर हमने लंदन में किया जून में, जहाँ पर हमारे साथ चीफ जस्टिस ऑफ इंडिया, लॉ मिनिस्टर ऑफ इंडिया एंड फॉर्चुनेटली जज ऑफ द सुप्रीम कोर्ट ऑफ यूनाइटेड किंगडम, ही वाज आल्सो देयर। हर ये इस प्रोग्राम में आइदर द एम्बेसडर्स मौजूद रहते थे। फिर रिसेंटली हमने 2 हफ्ते पहले सिंगापुर में किया, जहाँ भी हमारे साथ लॉ मिनिस्टर थे और सिंगापुर के जजेस भी थे। तो इस तरह हम कुछ थोड़ा बहुत काम कर रहे हैं टू मेक इंडिया एज ए हब ऑफ इंटरनेशनल आर्बिट्रेशन। सर, कोई भी बिजनेस, कोई भी व्यापार बढ़ नहीं सकता है, देश आगे उन्नति नहीं कर सकती है अगर हम आपस के जो मसले होते हैं बिटवीन कमर्शियल पीपल, commercial organizations, between 2 international firms, उसको अगर हम जल्दी से जल्दी रिजॉल्व नहीं कर पाए, we must resolve our dispute and differences in a very timely manner. अगर हम देखें दुनिया भर में, तो जितने भी डेवलप्ड वर्ल्ड हैं, जितने भी डेवलपिंग कंट्री हैं, हर जगह कमर्शियल डिस्प्यूट्स आर्बिट्रेशन के थ्रू रिजॉल्व होते हैं। बट मैं बेसिक कहूँगा मीडिएशन के थ्रू रिजॉल्व होते हैं, आर्बिट्रेशन से बेसिक। मेरे को मौका मिला टू एड्रेस सुप्रीम कोर्ट ऑफ वर्जीनिया, जहाँ पर जब मैंने अपना वाक्य रखा कि भारत में हम कैसे डिस्प्यूट्स को रिजॉल्व करते हैं, तो सब लोगों ने कहा कि आपके यहाँ तो रिजॉल्व लिटिगेशन के थ्रू रिजॉल्व होता है, एडहॉक आर्बिट्रेशन के थ्रू रिजॉल्व होता है। 90% of the commercial disputes in America is resolved through mediation. One of the judges of the Supreme Court, who was also here in one of the conferences, he also said that most of the developing countries in the world and developed countries in the world are either resolving their disputes through mediation, they are preferring to resolve their through mediation. अगर उसके कारण कोई कारण से असफल होते हैं तो फिर वो आर्बिट्रेशन में जाते हैं। पर आर्बिट्रेशन भी इंस्टीट्यूशनल आर्बिट्रेशन का होता है, कहीं पर भी आर्बिट्रेशन एडहॉक आर्बिट्रेशन नहीं होता है। जहां पर भी, चाहे आप अमेरिका ले लीजिए, चाहे आप ब्रिटेन ले लीजिए, चाहे आप कोई भी कंट्री में आप चले जाएं, चाहे आप फ्रांस ले लीजिए, जर्मनी ले लीजिए, जो डेवलप्ड कंट्रीज़ हैं और जो डेवलपिंग कंट्रीज़ हैं, इवन इन ए कंट्री लाइक उज्बेकिस्तान वेयर आई हैड अपॉर्चुनिटी टू एड्रेस, वहाँ पर भी आर्बिट्रेशन इज़ डन थ्रू इंस्टीट्यूशनल आर्बिट्रेशन। तो हर देश में जहाँ भी कमर्शियल डिस्प्यूट्स को रिजॉल्व किया जाता है, वहाँ पर यही देखा गया है दैट वो कमर्शियल डिस्प्यूट्स आइदर थ्रू मीडिएशन और या थ्रू आर्बिट्रेशन रिजॉल्व करते हैं। सर, रिसेंटली 23 जुलाई को हमारे एक बहुत माननीय सुप्रीम कोर्ट जज है सुधांशु जी धूलिया, उन्होंने कहा था दैट आर्बिट्रेशन इज ए रिच मैन्स लिटिगेशन। आर्बिट्रेशन, ये बहुत पुरानी बात नहीं है, कुल 23 तारीख की बात है कि आर्बिट्रेशन इज ए रिच मैन्स लिटिगेशन, पुअर डू नॉट ऑप्ट फॉर इट। मैं केवल, यहाँ सब वकील बैठे हुए हैं, ये पूछना चाहूँगा, इज litigation cheap in India? I don't think litigation is cheap in India. सर, हमने 2015 से 2025 तक ओनली थ्रू लोक अदालत 1400,000 केसेस रिजॉल्व किए हैं थ्रू मीडिएशन विदाउट मच ऑफ कॉस्ट, प्रैक्टिकली फ्री ऑफ कॉस्ट। सो ये कहना कि आर्बिट्रेशन इज मेंट फॉर रिच पीपल मे नॉट बी करेक्ट, यस, बट मीडिएशन इज वेरी इजी। आई मीन, लोक अदालत से हम तो मीडिएशन करते हैं एंड विदाउट कॉस्ट, एंड 1700,000 केसेस को रिजॉल्व करना 10 बरस के अंदर इज नॉट ए मैटर ऑफ जोक। सर, एक इंस्टीट्यूशनल आर्बिट्रेशन की जब बात करते हैं तो आप कोई भी इंस्टीट्यूशनल आर्बिट्रेशन को ले लीजिए, भारतवर्ष में जितने भी नामी गामी इंटरनेशनल इंस्टीट्यूशंस हैं, यहाँ के जो इंस्टीट्यूशन हैं, हमारा एडमिनिस्ट्रेटिव कॉस्ट, आर्बिट्रेटर्स कॉस्ट लेस देन 1/3 है। अगर वहाँ हम 10 रुपये खर्चा करते हैं तो यहाँ पर हमारे आर्बिट्रेशन का कॉस्ट 3 रुपये से ऊपर नहीं होता है। तो एक ये बहुत बड़ा एडवांटेज है, हमारी खुद की प्रोसीडियर्स होती है, हमारी खुद की टाइमलाइंस होती हैं। सर, हमारी फर्म जो खैतान कंपनी है, संजीव जी यहाँ पर हैं, हम लोगों ने 2024 में एक सर्वे किया था और 2025 में लंदन में एक यूनिवर्सिटी है, मैरी क्वीन यूनिवर्सिटी, उन्होंने भी सर्वे किया था। तो उस सर्वे में ये नतीजा निकला दैट पीपल वांट्स टू रिजॉल्व देयर डिस्प्यूट्स थ्रू नेगोशिएशन। संजीव जी, इफ आई एम नॉट रॉन्ग, दैट इट इज़ थ्रू नेगोशिएशंस, and people, if there is have to go for an arbitration, they would like to go for an institutional arbitration rather than an ad hoc arbitration. अगर आप सियाक की बात करें तो सियाक 1991 में एस्टैब्लिश हुई थी। जस्ट आपको एक फिगर देता हूँ, 1991 में। आप डियाक की बात करें दुबई, तो वो 1994 में केवल एस्टैब्लिश हुई थी। और अगर आप चाइना की बात करें तो वहाँ पर फर्स्ट आर्बिट्रेशन एक्ट जो आया वो 1995 में आया। सियाक 91, डियाक 94, चाइना 1995। हमारा आर्बिट्रेशन लॉ तो बरसों पुराना है। इस आईसीए की स्थापना 1965 में हुई थी। वी आर 65, तो कितने हो गए? आई मीन, वी आर नाउ हाउ मेनी ईयर्स ओल्ड चावला जी? आई थिंक मोर देन 60 ईयर्स ओल्ड। या चाइना में अगर फॉरेन आर्बिट्रेशन है तो उसको 6 महीने में रिजॉल्व करना पड़ता है, फ्रॉम द डे द आर्बिट्रल ट्राइब्यूनल इज फॉर्म्ड। और अगर डोमेस्टिक आर्बिट्रेशन है तो उसको 4 महीने के अंदर रिजॉल्व करना पड़ता है, फ्रॉम द डे the arbitral tribunal is resolved. There are more than 300 arbitral institutions in China today. So we want to make India as a hub of international arbitration. तो ये mindset हमको छोड़ना पड़ेगा that we have to see, and आप लोग को भी ये mindset रखना पड़ेगा that shun litigation, shun ad hoc arbitration, go for mediation, first negotiations, conciliation, mediation, and at the last resort an arbitration, and that is only through institutional arbitration. जब हम फॉरेन जाते हैं, वकीलों से बात करते हैं, तो हम उनसे पूछते हैं कि आप भारत क्यों नहीं आना चाहते हैं. इंडियंस आर, अगर वो डिस्प्यूट्स है बिटवीन ए कंपनी इन इंडिया एंड ए कंपनी आउटसाइड इंडिया, तो इंडियन प्रेफर करे या नहीं करे, दूसरा आदमी बोलेगा नहीं हम तो सिंगापुर में करेंगे आर्बिट्रेशन, या डियाक में करेंगे, या लंदन में करेंगे, विच इज द मोस्ट प्रेफर्ड सीट ऑफ आर्बिट्रेशन. और वो भी तो सियाक में द मैक्सिमम नंबर ऑफ आर्बिट्रेशन इज बाय इंडियन पार्टीज. वहाँ यहाँ क्यों नहीं करना चाहते हैं, हम यहाँ क्यों नहीं आना चाहते हैं. तो उन्होंने कुछ कंसर्न्स बताया मेरे को, मैं वो कंसर्न्स आपको बोलना चाहूँगा. एक कंसर्न था that we must have a certainty in law. सेकेंड उनका कंसर्न था कि आपके यहाँ कानून रेगुलरली चेंज होते रहते हैं, देयर इज अ फ्रीक्वेंट चेंजेस इन योर लॉ. थर्ड था कि आपके जो जजमेंट आते हैं उसमें कंसिस्टेंसी नहीं है, देयर शुड बी ए कंसिस्टेंसी इन योर जजमेंट. सर थोड़ा फ्रैंक बोल रहा हूँ, मोहित जी का इंस्ट्रक्शन था, देयर मस्ट बी ए कंसिस्टेंसी इन योर जजमेंट. थर्ड था दैट द कोर्ट्स ऑल्सो मस्ट ऑल्सो डिसाइड दैट जो भी उनके पास आर्बिट्रेशन आए वो इंस्टीट्यूशन में रेफर करें. हम ये नहीं बोलते आप आईसीओ को रेफर करिए, आप किसी भी इंस्टीट्यूशंस को रेफर करिए. हमारे यहाँ 2500 एक्सपर्ट आर्बिट्रेटर्स हैं सर, एंड केवल लॉयर्स और जजेस नहीं हैं, इंजीनियर्स हैं, आर्किटेक्ट्स हैं, पीपल हु आर एक्सपर्ट्स इन मैरीन इंजीनियरिंग, पीपल हु आर एक्सपर्ट्स इन कंस्ट्रक्शन कॉन्ट्रैक्ट्स, हर तरह के जो भी कमर्शियल डिस्प्यूट्स होते हैं उसमें जितने भी एक्सपर्ट्स हैं उस डोमेन में, उस डोमेन के हर लोग हमारे यहाँ आर्बिट्रेटर्स हैं. सो इट इज़, अपनी ये जो धारणा है दैट ओनली ए पीपल हु हैव पास लॉ कैन बी ए गुड आर्बिट्रेटर, वो धारणा कुछ तक सही भी है और कुछ तक सही नहीं भी है. दूसरे लोग भी अच्छा आर्बिट्रेशन कर सकते हैं, तो मैं ये मानता हूँ इस बात को. और एक उनका बहुत बड़ा कंसर्न था, और आज भी वो कंसर्न है, दैट वी हैव सेट असाइड द अवार्ड इन ए क्यूरेटिव पिटीशन. बड़ा बड़ा कंसर्न है सर, दैट राइट है रॉन्ग है मेरे को नहीं पता, बट टू गेट अवार्ड सेट असाइड ऑन ए क्यूरेटिव पिटीशन एज फार एज द इंटरनेशनल कम्युनिटी इज कंसर्न, उनका एक बहुत बड़ा कंसर्न रहा है इसके ऊपर. और अब वो और ये भी चाहते हैं कि हम डिजिटाइजेशन के ऊपर जाएं, वर्चुअल आर्बिट्रेशन करें, एआई का यूज़ करें. बट as far as the making of the award is concerned, that the arbitrator should not use AI. This is the survey, that no arbitrator should use AI as far as the making of the award is concerned. अभी रिसेंटली जस्ट हफ्ते भर पहले जस्टिस विक्रमनाथ जी जो अपने सुप्रीम कोर्ट के जज, उन्होंने कहा दैट AI cannot replace human conscious. AI cannot replace human conscious and the justice delivery system. तो जस्टिस डिलीवरी सिस्टम में AI का सहारा हमको नहीं लेना है. सर ये दिल्ली आर्बिट्रेशन वीक है, आज भी हमारे समक्ष कई माननीय गण्यमान्य वकील बैठे हुए हैं, वो भी अपना कुछ ना कुछ सुझाव देंगे। दिल्ली आर्बिट्रेशन वीक है, उसमें भी कुछ सुझाव आएंगे। बट हमें ये प्रण लेना है सर दैट इंडिया को, हम सब चीज में आगे बढ़ रहे हैं, वर्ल्ड इज लुकिंग एट अस, लोग यहाँ आकर काम करना चाहते हैं, लोग यहाँ पर इंडस्ट्री बैठाना चाहते हैं, हम भारत में आके निवेश करना चाहते हैं। और ये निवेश हो रहा है और होगा अगर हम इन्फोर्समेंट ऑफ कॉन्ट्रैक्ट को जल्दी सुलझाएं। जस्ट एक बायलैटरल इन्वेस्टमेंट ट्रीटी को लीजिए, एक बायलैटरल इन्वेस्टमेंट ट्रीटी, उसमें प्रोविजन है कि पहले आपको 3 साल लिटिगेशन करना पड़ेगा, फिर आप आर्बिट्रेशन में आ सकते हैं। मेरे को सर, आई स्टिल रिमेंबर द आउटबर्स्ट ऑफ जस्टिस ठाकुर दैट व्हाट इज द सिचुएशन ऑफ डिले इन जुडिशरी, उनका क्या कंसर्न था जुडिशरी के ऊपर। और हम बायलैटरल इन्वेस्टमेंट ट्रीटी में ये प्रोविजन कर रखे कि फर्स्ट आप लिटिगेशन करिए, फिर आप आर्बिट्रेशन करिए। तो ये एक इंटरनेशनल कम्युनिटी का ये भी एक बहुत बड़ा कंसर्न है। सर हम तो चाहेंगे कि देश आगे बढ़े, द वर्ल्ड इज लुकिंग फॉरवर्ड टू अस, वी आर कंट्रीब्यूटिंग 16% of the global growth today. It's a matter of pride, sir. It's a matter of pride. We may be poor in per capita income, we may be poor in, but on a purchasing power parity, our per capita income is not $2,300, but on a purchasing power parity, our per capita income is $8,000. We are not a poor country anymore. We are a developing country. And अगर हम disputes को जितनी जल्दी resolve कर सके, maybe either through mediation, arbitration और litigation, but ये हमारा प्राइमरी कंसर्न है और ये हमारा प्राइमरी कंसर्न रहना चाहिए। और इसमें हमको जुडिशरी की बहुत बड़ी सपोर्ट चाहिए, वकीलों का सपोर्ट चाहिए। आप अगर दिन भर एडजोर्नमेंट लेंगे तो काम नहीं चलेगा। इट हैज टू बी डे टू डे हियरिंग। आर्बिट्रेशन हैज टू बी टेकन एज ए सीरियस बिजनेस बट नॉट एज ए पार्ट टाइम बिजनेस। वी आर डूइंग एज ए पार्ट टाइम बिजनेस। दिन में आप कोर्ट में लिटिगेशन करेंगे, 2 घंटे के लिए आप आर्बिट्रेशन करेंगे, वो नहीं चलेगा। इट हैज टू बी ए फुल टाइम बिजनेस सर। आइदर आप आर्बिट्रेशन करिए या लिटिगेशन करिए। यू हैव टू टेक आर्बिट्रेशन वेरी सीरियसली। तो हम यहाँ मंच में आके बात करते हैं आर्बिट्रेशन की, तो हमको भी, अगर हम जुडिशरी को बोलते हैं कि आप जस्टिस डिलीवरी सिस्टम में बिलीव करिए, आप जल्दी से आप जजमेंट बिलीव करिए, डिले नहीं होनी चाहिए, तो हमको हमारी भी कर्तव्य बनता है कि हम भी उस धर्म के साथ काम करें कि जल्दी से जल्दी एडजमेंट नहीं मांगे, थोड़ा बहुत प्रो बोनो भी काम करें, हेल्प करें। ये नहीं कि केवल पैसा ही कमाने के लिए काम करें, वॉट एवर इट इज़। बट मैं ज़रूर समझता हूँ दैट अगर जुडिशरी हमारे साथ है, वकील हमारे साथ हैं, इंडिया विल गो मेनी वे फॉरवर्ड्स, हम बहुत तरक्की करेंगे। धन्यवाद, थैंक यू वेरी मच।
Thank you, Khaitan sir, for your insightful remarks and for laying a strong foundation for today's deliberations. May I now turn to our chief guest, Honorable Mr. Justice Prashant Kumar Mishra, Judge Supreme Court of India, to enlighten the gathering.
Mr. Arun Chawla ji, Director General of ICA and former Director General of FICCI, Dr. N.G. Khaitan, President ICA and Senior Partner Khaitan and Company, Brother Justice Jasmeet Singh, Judge High Court of Delhi, Dr. Pinky Anand, Senior Advocate, former Additional Solicitor General of India, Ms. Geeta Luthra, Vice President ICA and Senior Advocate, Supreme Court, Mr. Mohit Saraf, Founder and Managing Partner, Saraf and Partners, Mr. Sanjeev Kapoor, Partner Dispute Resolution, Khaitan and Company, Mr. Ganesh Chandru, Advocate and Arbitrator, Partner Dua Associates, Professor Pankaj Chaudhary, Assistant Professor, Faculty of Law, Delhi University, Mr. Mayank Singh Thakur, Senior Partner and Country Head, India, Masin. The DAW committee members, some former judges are also here, and other distinguished participants and members, ladies and gentlemen, members of print and electronic media. आज हिंदी दिवस है और जब मिस्टर खैतान मुझे हिंदी में समझा रहे थे क्यूरेटिव पिटीशन का जिक्र करके, तो सहसा मेरे को ये याद आ गया और सुबह से दुनिया भर के व्हाट्सएप में मैसेज आ रहे हैं हिंदी के बारे में, तो मैं भी सोचा कि क्यों ना हिंदी से ही शुरुआत करूं। और एक बड़ा इंटरेस्टिंग मैसेज है खैतान साहब की बातों को आगे बढ़ाते हुए, हिंदी में समझाऊं क्या। अरबी बोली भी जाती है और खाई भी जाती है, चीनी बोली भी जाती है और खाई भी जाती है, अंग्रेजी भी बोली जाती है और पी भी जाती है। मगर हिंदी एक मजबूत भाषा है, ये सिर्फ बोली जाती है, क्योंकि अगर कोई एक बार कह दे कि तेरे को हिंदी में समझाऊं क्या, तो सामने वाले को अपने ही आप समझ में आ जाता है। ये हिंदी की ताकत। मेरी तरफ से आप सभी को हिंदी दिवस की शुभकामनाएं। और जो भी खैतान साहब ने समझाया है मुझे थोड़ी थोड़ी समझ में आ रही है, क्योंकि हिंदी में बताया गया है। तो कई बार अंग्रेजी में प्रॉपर जगह पे नहीं पहुंच पाता है आपके ब्रेन में, तो हिंदी में सही जगह पे पहुंच जाती है बातें। लेकिन साथ में उनने ये भी बोला है कि आर्बिट्रेशन इज ए सीरियस बिजनेस, तो मैं कुछ सीरियस बिजनेस को भी आगे बढ़ाता हूं। And let me open by saying that it is an evening of immense pleasure for me to speak at an event organized by the Indian Council of Arbitration. Few institutions in India have played such a sustained and vital role in shaping and practice of judiciary, particularly the commercial arbitration, as the ICA has done. Formed in 1965 through the vision of the Government of India and leading business associations, the ICA was created at a time when India's commercial landscape was beginning to open up to new challenges and opportunities. Its founders recognized that if commerce was to flourish, businesses needed a trusted alternative forum that could offer resolution that was swift, efficient, and practical. This would enable parties to settle their disputes and return quickly to their affairs. Over the decades, the ICA has remained true to that mission. It has built a reputation as a neutral and professional institution, maintaining a distinguished panel of arbitrators administering both domestic and international disputes, and constantly adapting its rules and practices to meet contemporary needs. In doing so, it has not only provided parties with reliable mechanisms for resolutions, but also helped strengthen confidence in India overall as a hub for arbitration. I also appreciate that beyond administering cases, the ICA has also been a thought leader. Through its engagement with the wider ADR community, it has nurtured expertise and awareness across the profession. It is therefore entirely appropriate that we gather here under the banner of ICA to reflect on the present and future of ADR ecosystem in India. In our Indian culture and society, there is a long-standing concept of mediation and arbitration. And when we talk about mediation and arbitration, it is always an element of persuasion. और मैं फिर हिंदी में आऊँ तो परसुएशन का जो हिंदी मतलब है वो इतना गहन है, इतना तार्किक है और इतना सीरियस है कि वो अपने आप में एक वेपन है. उसका हिंदी में मतलब होता है फुसलाना. जब आप किसी को परसुएट करते हैं तो you drive him to a situation where he agrees with you. In mediation, in arbitration, in negotiation, there is an element of persuasion always. And that persuasion या फुसलाने की प्रक्रिया वो अपने आप में इतनी सारगर्भित है. And that is why we have been taught the elementaries of or the concept of arbitration and mediation since time immemorial, since ages. And we often quote how Krishna tried to persuade Kauravas and Pandavas to enter into a negotiation. Give 5 villages instead of the whole empire, the whole Hastinapur. And if negotiation fail, arbitration fail, mediation fail, the result is Mahabharata. That is the lesson we have been taught all throughout. In Kautilya also, the Arthashastra of Kautilya, he spoke eloquently about different categories of dispute and presently emphasized that for commercial disputes, negotiation and compromise were the preferable alternative to prolonged adjudication. In Narada Smriti, it gave binding force to decisions of merchant guilds. In medieval South India, powerful guilds like the 500 lords of Ayyavalu had established mechanisms to settle disputes swiftly so that trade could continue unhindered. The impulse has always been the same. In commerce, disputes must be resolved quickly, fairly, and conclusively so that enterprise may move forward. These traditions show us that what we now call ADR has always been part of our rich culture and our sense and approach to justice. ADR, whether it is arbitration, or anything else within the compass of ADR, it is part of the whole justice delivery system. We cannot separate ADR from the system. There is no conflict between the traditional justice delivery system and ADR as we know. And it is precisely for that the whole ADR system is institutionalized in India. like elsewhere in the world, as Mr. Khaitan was saying, in different countries, this arbitration has been institutionalized, codified, and they are in different stages of implementation and strengthening them. And we have marched ahead. Though London and Singapore are also a bit ahead of us, we should not shy of admitting what is reality. They are slightly ahead of us, but we are not that behind when we can say that we are at a very nascent stage. No, it is not. And the way law has developed and the legislation is developing every passing day, we think in times to come, probably we will have the best ADR system in the world. As we are now, as we proclaim and probably write also, that we are the fourth largest economy in the world and on the cusp of being the third largest economy by the end of this decade, probably this could not have been achieved without there being a robust ADR system. Any economy to grow and any economy to be third largest in the world has its all components growing. Unless we have a robust justice delivery system, which essentially includes a robust ADR system, we cannot be the fourth or third largest economy. Because to be an economy of that size, you have to be the foreign institutions having trust in you. And any businessman is always more sharp than any other person, be a lawyer or a judge. So any international businessman will not come to India unless he examines beforehand this system in any country which is at the stage of entering into a contract, then execution, and then post-execution. They are not fools that they are coming to India without us having any proper system of justice delivery. Of course, there are few instances, I will not call it aberrations. Mr. Khaitan has the liberty to call it, but I cannot call it. But at the same time, whenever there is a new interpretation of a law, there will be criticism and there will be views on both sides. What people see is one side, what both the litigants see is another side, what the government sees and perceives, the fact situation in the life of a litigation when it begins is different. And when it is at the culminating point, the views and perspectives about the litigation and the impact of the outcome is different. We cannot find fault with any particular judgment only on the basis of one reading without knowing the background facts. And if there is a mistake committed by any decision-making body, it will be corrected in due course. As we say that ADR or arbitration and mediation, it's a consensual process. There has to be a consent of both the parties because that ends the litigation, shortens the litigation, and gives confidence to the warring parties and to the whole system also. An arbitration or mediation cannot happen without consent of the parties, consent about finality also. And like things are happening in this global scenario, someone is claiming that I have done this, I have bring the parties to compromise, the parties are denying. That cannot be an arbitration. There is so much written about this whole ADR tapestry, and weaving is an essential part of any arbitration. The threads which is picked up at the beginning has to end in a sari or in a shirt. So that nice outcome, that pleasant outcome of weaving has to be there in any litigation. And ADR is also, arbitration and mediation is also a kind of litigation. We cannot separate litigation by naming it mediation. At the end of it, it is a litigation. It is only a way of resolving the litigation. Litigation doesn't mean that it has to be, has to be a court of law to decide. When there is a dispute, you can treat it as litigation. And when Mr. Khaitan was saying that litigation is costly in India, who else knows it better than Mr. Khaitan himself? Anyway, I wish good luck to all the participants, and wish good luck to ICA, that the whole week would be very fruitful, and we together we will be able to build a robust ecosystem, a resolution, arbitration and mediation ecosystem in India. The development of this ecosystem will continue, whether it is today or after 10 years. And then after 20-30 years also, we'll talk about the same thing, how to strengthen it further. But thus far we have reached, it is not a small thing, whatever India has achieved in strengthening this system, and we hope it will be rock solid in times to come. Thank you so much.
Thank you, sir, for your profound and insightful address. Your remarks have laid a thoughtful and intellectually robust foundation for the discussions ahead. As the inaugural session culminates, I once again invite Mr. Arun Chawla to deliver the closing remarks.
Ladies and gentlemen, what an enriching session. The addresses collectively underscore a fundamental truth. Alternate dispute resolution is no longer a peripheral legal mechanism, and no longer a static one too. From the words of wisdom as elucidated by the Honorable Justice Prashant Kumar Mishra, we surmise that ADR has become a strategic cornerstone of market confidence, encouraging both domestic and global businesses to invest, collaborate, and seek dispute resolution in India. To be precise, the tapestry of business-friendly nation is incomplete without the threads of effective, efficient, and dynamic ADR framework. Thank you, Justice Mishra, for taking your precious time out to enlighten us with your perspectives and your laudatory remarks about ICA. The mythological examples given by you to illustrate the power of arbitration and mediation convinces us about the power of dispute resolution mechanisms. Your emphasis that there is no conflict between ADR and litigation encourages us as ICA to push ourselves in the mission to make India the hub of international arbitration. Ladies and gentlemen, as we navigate a rapidly evolving legal and technological landscape, it is crucial to assess how swiftly our ADR framework is adapting. Today, we find ourselves at the pivotal juncture, tasked with building a cohesive, globally competitive arbitration mediation ecosystem that not only meets international standards, but also keeps pace with the dynamic technological shifts that emerge with increasing frequency. As we move forward in this symposium, the upcoming panel discussion will delve deeper into these interwoven themes, and I am confident that the dialogue ahead will enrich our collective understanding and spark meaningful practical collaboration. Ladies and gentlemen, our chief guest has shown a compulsion to leave after this session. So, with much reluctance, we will allow him to go, but not without a thumping round of applause for him.
So then take out one chair and we'll all move one step forward.
Oh, I think she's trying to.
As we now move towards the panel discussion, it is my privilege to introduce the moderator for this session, Dr. Pinky Anand, Senior Advocate and former Additional Solicitor General of India. Dr. Anand is an internationally acclaimed arbitrator, a published author, and a distinguished authority in the field of private international law. We welcome you, ma'am. This session promises to provide profound insights and a range of perspectives on the topic at hand. Without much ado, I would request Pinky ma'am to take over.
Thank you, Akshita. While we were waiting to start again, I thought I would spend the time without the mic to engage in conversation with all my colleagues. Indeed, it's a delightful position to be in, and I think Justice Mishra has started the ball rolling rather interestingly, taking from the subject. He's used the tapestry and the weaving concept throughout in his discussion in the context of arbitration and even litigation, equating the two at the same time, pointing out the differences, but ultimately hailing a period of the Indian economy which invites and accelerates business, investment, growth, which is all essential. We can't manage without that, and we are managing very well. But having said that, the other interesting part that I thought he kind of targeted on was the fact that we are constantly evolving, and that is something that we have done, incidentally, in the field of ADR. We have made more amendments than possibly almost any other country in the world, having started in 1940. And constantly we are evolving, and I liked what he said, that even 20 years later, we'll be sitting back and again thinking of what better to do. So I don't want to, at this point of time, go into all the things that I have. In fact, when I was looking at the statements that I wanted to make, most of them were suggestions, again, of improvement of system. But having said that, we have got very far. We have got started from litigation. We started from panchayats. I'm wrong. We started from panchayats, where Kautilya's, Arthashastra, everything that Justice Mishra said, went on to litigation, and then came back again as a kind of semicircle, came back to arbitration. From arbitration and conciliation, then we came back to mediation. Now, recently there has been an immense move after the Singapore Convention, and we've been targeting as far as the Mediation Act is concerned. And believe it or not, the whole focus has been to target on that area, because particularly in commercial disputes, the focus of a mediation would lend to better businesses and growth of businesses. It's only money at the end of the day. It's nobody's life, it's nobody's liberty, it's money. And if you can sort it out, ultimately the engagement to carry on a further process is so much higher. Therefore, the entire emphasis that the government has chosen to put down on mediation, of course, there we have some suggestions. I mean, I'm all for mandatory mediation. I believe in Section 12A of the Commercial Courts Act, and I think giving an option, I know this was highly debated. All of you were party to that discussion. But at the same time, giving an option and voluntary mediation is something that really needs to have a look on. But we keep evolving, as Justice Mishra was saying. I also look at another concept of having compulsory mediation at the end of mediation, before arbitration, or at the end of arbitration before it concludes. You concluded in arbitration, you're waiting for the result. Have another compulsory mediation. It might lead to a result which might be more acceptable. And today mediation orders, ultimately, or mediation settlements, in fact, are enforceable. That much is a matter of record, and we continue with that exercise. So I think these are some of the questions that come across with us, and we are constantly trying to see. We become a service-oriented industry as far as the country is concerned. We also want to give services in the direction of justice delivery system, in the development of ADR. So the development of arbitration by itself as an ADR mechanism, making India an ADR hub and bringing everybody here. But to do that, I think Mr. Khaitan had pointed out, or Mr. Chawla had, the 3-year litigation period is something that is, well, big question mark. And the bilateral investment treaties, there's askance on that. There's been cancellation of several. We need to keep relooking. We suffered wide in industries, but then after wide in industries, we have to go another step forward and start negotiations again. And that process is again an involving one. So with this in hand, I think I'm going to, for the time being, go on to my panel, who are each of them, one better than the other. And the most, we'll start with the most enjoyable gentleman, who's been acclaimed for his appreciation from the bar and bench alike for the virtual courtroom around midnight after 13 hours of continuous hearings. Honorable Justice Jasmeet Singh, who I have known for a long time. I have had the pleasure of working with him. He is also currently very appropriately on the arbitration side of the judicial system and the justice delivery system. He's been having about 27 years of experience in service in civil law and practice, of course, in the Delhi High Court earlier, and now he's sitting there as one of the most amenable, happy, I shouldn't say amenable, that sounds like not a right word, a very amiable, let me put it like this, and a very justice-oriented judge who seems to be liked by everybody all across. Thank you very much. So, Justice Jasmeet Singh.
Dr. Pinky Anand, Ms. Luthra, senior advocates, Mr. Saraf, Mr. Kapoor, other distinguished members present, arbitrators, dear friends, good evening. At the outset, I must acknowledge that the theme chosen for today, ADR Tapestry, weaving a resilient arbitration and mediation ecosystem in India, is not only beautiful worded, but is profoundly meaningful. As Justice Mishra said, a tapestry, as we know, is a fabric woven with many colorful threads, each thread adding strength and beauty to the whole. In the same way, our dispute resolution system cannot rely on a single strand. It needs negotiations, mediation, conciliation, arbitration, and even online dispute resolution, all woven together to create a strong, flexible, and inclusive system of justice outside courts. In the past, India had faced challenges in embracing ADR, especially arbitration, as the preferred method of dispute resolution. But today, we stand at the threshold of a new era. The legislative reforms of 2015, 19, 21, the enactment of the Mediation Act 2023, the judicial support have all added threads to this fabric. Slowly but surely, India's ADR framework is not only aligned with the international best practices, but also responsive to India's unique needs. Having said that, I am firmly of the view that ADR still has a long way to go. Our courts are heavily burdened, lakhs and crores of cases pending. In this system, ADR offers a path forward, faster, cost-effective, and less adversarial. But for ADR to truly succeed, arbitration is not enough. Mediation also is not enough. We need the entire tapestry, carefully woven, each strand supporting the other, where negotiation encourages a dialogue, mediation builds bridges, preserves relationships, arbitration gives finality and neutrality. In this digital era, online platform brings accessibility to even the remotest corners of our country. Together they create resilience and ADR tapestry strong enough to face the challenges of our time. In our country, this weaving process is already underway. The Arbitration and Conciliation Act 1996 has been progressively amended to achieve the object and purpose. The Mediation Act 2023 marks a new era in institutionalizing mediation. As arbitration commands a global stage, mediation is rising, in tandem with our domestic ecosystem. According to NALSA, nearly about 98,000 cases were resolved through mediation from April 2024 to March 2025. Now, with the statutory recognition in place, I am sure that the number will gradually rise. However, to my mind, we need awareness campaigns, training of arbitrators, mediators, and most importantly, to build trust and confidence among citizens that ADR is not a second-class justice mechanism, but a first choice for effective resolution. Having said that, weaving of this fabric is not the responsibility of lawmakers and courts alone. It requires collaboration across the spectrum, lawyers who advise clients to embrace ADR, business that embed arbitration and mediation clauses in their contracts, academic institutions that train the next generation of ADR professionals, and a judiciary that continues to act as a supportive partner. Ultimately, resilience comes from adaptability. As technology reshapes transactions and disputes, online dispute resolution must be stitched in our tapestry. As global commerce becomes borderless, we must align with international best practices while retaining our cultural strengths. Disputes become more complex with each going day. We must build capacity, not just in procedure, but also subject matter expertise. The strength of reforms lies not only in enactments, but in their application. Every amendment, every judicial amendment, every pronouncement, every institutional effort is like a new thread woven in this tapestry. We must continue to weave. Strength comes not from uniformity, but from diversity. Before I conclude, I must flag 3 to 4 issues which must be addressed and which, according to me, require attention. I have been on the arbitration roster for about 6 months plus. There are things which keep cropping up, which are, according to me, which are to be addressed to make this ADR system more effective and to build a confidence amongst the commerce people, amongst the business houses. First is the timelines for concluding post-award proceedings. In my roster, I have 34 petitions, 37 appeals pending from 2017-16. That, according to me, is not a way where the ADR will get strengthened. We must have timelines, 12 months, 8 months, 16 months, depending on the rush or the workload of a particular court. But until and unless we strengthen our arbitration act to say 6 months plus 12 months plus a 29A application, but if we don't put a closure by putting a timeline for 34 petitions, it is an exercise in futility. Secondly, my other question is, have we achieved the concept of limited court intervention? We have a hands-off policy, but some of the awards, if we don't interfere, they cry, it's written all over that please interfere with this award. So on one side, the emphasis is that it's a dispute resolution mechanism by choice, party autonomy, but on the other hand, there is also a line of thought which says that courts must keep hands-off policy, but the law keeps changing, or there are always these subtle nuances which keep saying that it must be interfered, and some of the awards, frankly, need interference like how. Then another aspect is the delay in enforcement of arbitral awards. so many cases which I have seen that there is an award, and by the time we go in for attachment under Order 21 or we go for some coercive action, by that time the moratorium under Section 14 has already kicked in, the judgment debtor is also already under IBC, or proceedings are already, CIRP proceedings have already been initiated. So again, the moment there is an award, the moment a 34, there's a timeline for a 34, the time gap or the time lag between an award and enforcement should not be too long. Another important aspect which I see is our training to the arbitrators and mediators. By and large, the judicial awards by judicial judges, retired district judges are sound, but some of the awards by non-judicial people, in their minds they have rationalized their award. In their minds they have given reasons, but when we are scrutinizing the award under 34, reasons are not there, the evidence has not been discussed, so that the arbitrators must be given training to see that these are the things which must be met in an award. Lastly, which I feel very strongly, is that there must be specific courts to deal with arbitration and mediation matters. We have in the Delhi High Court, we have a dedicated roster. But I think we should have something like an arbitration division where the latest international laws are brought to the notice of the judges who are dealing with it. They have LRs who are specially in sync with the arbitral laws all over the world, so that the 34 petitions, the enforcement petitions, are decided expeditiously. With these remarks, what I say is that even though much progress has been made, still there remains to be things done. As Dr. Anand said, that 10 years later, we will be saying that how do we make it more robust? That discussion will always be on, but I think for the time being, we are good where we are. Thank you.
Well, in his own humble way as usual, Justice Jasmeet Singh has put down, I think, his experience, which is, I think, the most useful. We come to understand how systems function, and that is half the battle, if not 3/4 of the battle. So I was just thinking of two of the points that he made in particular. So this has been bothering me a lot. We keep saying there should be least judicial intervention. It's a very good philosophy. The rule of law should prevail, arbitration should have a finality, so you don't challenge it. But at the end of the day, there are those instances, what Justice Jasmeet Singh pointed out, that you have awards which stare you on the face and say, help, some help is needed. And I do believe that it has to be on a case-to-case basis and in an arbitration-to-arbitration basis. While we minimize judicial intervention to some extent, minimize, restrain, confine it to some extent, at the same time, where the occasion demands, it must be done and it should be done. I think in the same light, in fact, the arbitration bill of 2024 is focusing on an arbitral tribunal, which will also have confined limits on intervention, but an arbitral tribunal, to that extent, somewhat of another deviation to try and help matters to progress faster. While we speak about training to arbitrators and having their specialized courts, I think least judicial intervention tiers in addition may be a very useful mechanism. So I have been at least thinking aloud. I don't know how many of us agree or don't, but it's a room for debate. Should we minimize, not have 34, 37 and Article 136? You increase the tiers, you obviously will have more litigation. And in India, we are very big stalwarts. We go right up till the end. We won't leave anything alone unless and until, for example, a mediation settlement is made and that becomes binding and it's ultimately enforced, even though today we don't have an international mediation. settlement which is enforceable. We haven't followed the Singapore Convention as far as that is concerned. So with these small observations that I have, and I thank you very much, Justice Jasmeet Singh, for enlightening as to what it must be and how adjournment shouldn't happen and how things should function within prescribed time limits, like we have in the Arbitration Act for the awards. Let us have the same kind of parameters for Section 34, 37 till they remain as they are, and hopefully we'll at some stage even possibly distinguish between domestic and international. That is something again we need to consider. So far we've been having a unitary come binary method for domestic and international. But maybe we must start thinking aloud on how we can minimize these tiers on one level, both or alternatively, whichever way. So with this, Ms. Geeta Luthra, who's of course a stalwart in ICA, she's the Vice President of ICA, a senior advocate in the Delhi High Court and Supreme Court, accomplished arbitrator who's handling several high-stake, I believe, international and domestic arbitrations. It's another matter that we were partners for a long time, so everything that I have to say is always one of the highest commendments that I can give, but indeed an excellent counsel in all respects. Ms. Luthra.
You know, it's very difficult to speak after such wonderful speakers, particularly a person who is sitting on my right, just immediately on my right. And it's always a pleasure to be in his court. And you learn, you see how arbitration is working in practice, and that's why some of the examples that have been given are indeed what are brass tack issues which we face in arbitration day to day. So the question then is, in this alternate dispute resolution, what is it that we are trying to target, and is it really? For example, the UK has talked about it now as the primary dispute resolution. So it's saying the alternative is litigation. Dispute resolution through mediation, conciliation, arbitration is the first step and is the most important step. And then it says, this is primary and that is alternate. So it's really turning it on its head. So I just want to start with the quote from Sandra O'Connor, who was a US Supreme Court judge. And she's talking about the US. And in this context, I will also speak about Frank Sandler in a bit. But let me start with Justice Sandra Day O'Connor. The courts of this country should not be the places where resolution of disputes begin. They should be the places where disputes end after alternate methods of resolving disputes have been considered and tried. So now in India, we did have, and we all hark back to this, we did have the panchayat system. So that was the dispute resolution system. Over the years, we have adopted the adversarial common law system. Now, the common law system has actually worked extremely well because there are two lawyers, one bringing the plaintiff's viewpoint, one bringing the defendant's viewpoint. Both viewpoints come and then the judge or the court decides. Adversarial is good as long as you don't have so many lakhs of and crores of arrears of cases. Then you are looking at how to resolve them. And clearly one of the ways is conciliation. The other is mediation. And finally, if you can't do it through voluntary means by both parties agreeing, then is arbitration. Now, why is mediation gaining traction all over the world? So you had the Singapore Convention of 2018. India became a signatory, but we've still not ratified it. Pinky just talked about that. We need to ratify the Singapore Convention if we have to make international mediation a reality. Question is our mental ethos built to go for mediation? Or do we think mediation is a soft option? Because we know ultimately the other party can't be forced. We know we can't be forced. So sometimes people say, all right, once litigation fatigue sets in, you go in for mediation. But if we were to think of mediation or conciliation as the first option, then the possibility is you'd actually get rid of the bitter dispute arena, and you would perhaps be able to resolve matters in a much more amicable manner. Now, is that possible? Are we all mentally attuned to it? The US, the UK, Singapore, Australia have all been bought in processes where they are saying, please come to court and tell us what are the efforts that you have made towards mediation. In India, we don't start with that. So the Commercial Courts Act 2015 was the front runner. It's put in section 12A, which says that pre-litigation mediation is mandatory. Then obviously, when you have an urgent relief, you are saying, no, I have to rush to court because I need relief. And then the question comes, but pre-litigation mediation is mandatory. And the Supreme Court I think it is in Patil Automation, has said, no, it is mandatory. So we can't just run roughshod over it. The MSME Act provisions are all disputes pertaining to MSME cases. Section 18 mandates that you should have an attempt at conciliation before the Facilitation Council. That's mandatory. But again, people are hesitant to go. Maybe both parties don't even know that this is an MSME. So there has to be more traction when you are dealing with an MSME. There have to be clauses in the contract which says, look, there is a provision for Section 18, and that's mandatory. So if we start bringing that in and bring a timeline, like for example 4 weeks or 6 weeks, in which you have to mediate and then come to court, then there is a possibility that people will not feel so scared that this will be an endless process. And every time you come to court, a lot of the courts will tell you, have you tried mediation? And then you go back to mediation. So then some people say, no, litigation fatigue should set in before people are ready to go to mediation. But on the other hand, mediation is reasonable. Justice Karya yesterday or day before, in few days ago, said mediation should have the same fees or same economic ethos attached to it. I just feel, in fact, arbitration has to reduce its fees rather than mediation has to increase. And I'm very happy with the fact that there is Schedule 4, which is proposed to be taken away. They said the institutions will decide what the fees are going to be, and where it is not institutional, where it is ad hoc, councils will decide. Now that, I feel, is us going up and down. I think it is perhaps Justice Nariman who once said that are our amendments like a crab? Instead of moving forward, they are moving sideways. We have to see, we don't want a crab. We want to move forward. We want to have certainty of fees. How you do the certainty is something which has to be decided either in the enactment or in the rules or in the schedule, because all arbitrations are not institutional. I think one of the issues which I have with arbitration in India is that institutional arbitration has to be increased. You'll see better case management, you'll see better arrangement. It is mandatory that after even an award is made, it is looked through by those who are doing case management to see that all the necessary parameters have been looked at. So to that extent, I feel that mediation is something which we need to look at today, but we need to have both in arbitration and in mediation, as Justice Singh pointed out. You need to ensure that somebody has taken care of looking at the rules of evidence, ensuring that if evidence is required, it's there. You don't want an award to be set aside, but you don't want an award to pass muster if there are major infirmities in it. And these are issues which we need to train arbitrators, we need to train mediators. And in a sense, we have to look at having internationally trained arbitrators and mediators, so that Singapore has confidence in my arbitrators. I have confidence in Singapore arbitrators, because we see that we've all gone through the same kind of training. And same for mediators, same for arbitrators. I feel that is one aspect of the ethos. The other aspect, which I had said, if I'm not running out of time, is on emergency arbitration and emergency awards. And so one of the greatest aspects of Indian dispute resolution is, if you need an interim order, where do you go? So in arbitration, you go in Section 9. You go after an arbitrator is appointed to Section 17. But the question is of emergency arbitrators. And in the Amazon versus Future judgment, the Supreme Court, the courts recognize that there is enforceability of foreign emergency arbitrator decisions. Now, in the meantime, both ICA, DIAC, the Mumbai Center, all of them have bought in clauses for emergency arbitration. And I believe that this is one of the proposed amendments among many. So with that, I want to leave it with my learned friends, but as long as we have a redressal mechanism which is emergent, beyond that, I do believe that mediation and arbitration, if they are time-bound, and if there can be something like an arbitration followed by a mediation followed by an arbitration, perhaps that is what is important for the future. Thank you.
Well, thank you very much, Ms. Luthra. Interesting concepts. I think we are grappling with those, and while we are talking, we are also dealing with them. So what Ms. Luthra suggested, the med is some combination that we are trying, and we've been actually trying it. I was surprised to find that in family disputes also, in property, not talking about other type of disputes, actually these processes are well tried, directly or indirectly. So you had those processes happen. Also, the emergency arbitration and other issues, we found at times now the courts are deciding the principles, but thankfully the government has also now proposed it in the amendment of 2024, where it is getting statutory recognition. But indeed, we are looking at an era of judicial evolution. in arbitration, or ADR if you might say. So and I like that expression. Is it primary or is it secondary? But this dispute always goes on, the cat and the mouse. Whichever way it does, we need to resolve the disputes. Ease of doing business is the hallmark of what we do, and the duty of enforcement of contracts is one of the essentials that we need to deal with. So with this, we'll go on to Mr. Mohit Saraf, who's the founder and managing partner of Saraf and Partners, one of the most outstanding people in the fields of commercial disputes. Should I say resolution also, Mr. Saraf? Yes, and resolution also. Mr. Mohit Saraf, for you.
I just want to basically talk a little bit about what Mr. Khaitan said, but I'll come to a little bit in between. But really what we are talking today, I think I just want to give some numbers so that you are able to appreciate where we are today. We are a $4 trillion economy, and whoever you talk to, somebody will say that we'll be $10 trillion in 8 years, somebody will say in 12 years. Let's take the worst case, 12 years. So we're going to add $6 trillion in next 12 years. Virtually, to add $1 of GDP, you need to invest 55 cents. So therefore, we are talking about adding $3 trillion of investment in next 10 years. And that would require humongous amount of dispute. That is more important. Right now, if you think about it, I think Justice Jasmeet mentioned a number of things, and I want to talk a little bit, because really, this is the level of opportunity and this is a level of challenge in front of us. Right now, the courts have a lot of challenge with pendency matters. Just to give you some facts and figure, at the first level of litigation in India, it takes 1445 days. Compare it to Singapore, it takes 175 days. So we are that difficult. And I think Justice Singh said that we required a lot of these strong efforts. So really the arbitration, the entire arbitration and mediation was brought in because of this 1445 days, that arbitrators will spend time, quality time, and come up with an award, because some of these contracts are humongous contract, too many papers, and they can look at it and decide in an efficient manner. Therefore, I think we had an Arbitration Act in 1996, and we have had a lot of changes. I think we heard about the amendments. But again, if you think about in India, if there is changes, that is positive, because people are realizing the mistakes and changing it. Sometimes in India, we don't change law, and the mistake stays for decades. So that's a very, very positive thing. But really, if you look at the three big aspects of the amendments, which happened in last 10 years, 15 years, is confidentiality. One big aspect was confidentiality. And I'm going to talk about, I think I will talk about what Mr. Khaitan said, that we should be free and we should speak openly. So we'll talk about what it aimed and what it led to. So one is the confidentiality part, that because arbitration globally should be confidential, it should not leak out, things like that. The other issue which was equally important was removing court scrutiny. I think Justice Jasmeet Singh said that there are a lot of arbitration where it stares out. So therefore, I think initially the thought process was that we need to remove court's intervention. And that's very important. And strengthening institutional framework. I think that is what Mr. Khaitan said, that is what Mr. Chawla said, and that's an important part. If you look at the mediation, and I think really what I'm going to talk about is where we are today and what are the challenges ahead. How do we make sure that the rule, the path is much better. Mediation also, we have an act. We have not really, we have signed an arbitration convention, but we have not adopted it. But that's not too much of a problem, because that's only related to international mediation agreement. Really, for domestic law, we have a law. So really, I want to talk a little bit about what are the challenges. The real key challenge is that we don't have an institution. We don't have strong institution with so many case laws and so many precedents that they can manage it. I think that's where the biggest challenge is. And it's a chicken and egg situation, because they have less matters, so therefore all the significant transaction goes overseas. And that is something we should all ponder about it. Really, if you look at the new Supreme Court judgment, even the two Indian parties can choose seat outside and can come and enforce a judgment as a foreign award. And we need to understand why is it being done, because there's some problem here and we need to fix that problem. So really that is an important part, the lack of institutional arbitration. ICA is doing an excellent job. MCIA is doing a good job, but I would say that we need to build our institution. I think that's the first important part. What it does is really is what is very important. Jasmeet Singh said that really what the institution does is it makes sure the awards are well-reasoned award. That's an important part what you mentioned, and therefore it doesn't stare out. And that is a big problem, that a lot of time we believe that we need to do ad hoc arbitration, but there's nobody who can look at to check the boxes. And that is a big challenge. And I think a lot of us believe that ad hoc arbitration is cheaper, which is absolutely wrong. Institutional arbitration, even SIAC is cheaper than ad hoc arbitration in India. And that's an important part. I think all the corporates should go back and think about it. That cheap is wrong word. The time it takes, and everything is much more ad hoc, is much more expensive because there's nobody to look at it. There's no quality control. If you look at it, really at the end of the day, we were trying to look at, like, basically, we build so many checks and balance that only on public policy, on certain grounds, you can look at the award. And then you have Gayatri Balaswamy. I think in my view, and then you have this DMRC case, everybody talks badly about it, but really if you think about it, that we basically believe that removing court oversight will make sure that the awards are reasoned and well thought. That is where we have failed. Clearly all these cases are bad ideas, but it is because what Justice Jasmeet Singh said, that a lot of things stares out. And therefore we have to understand that why, when we started the entire policy of arbitration and mediation, we said 1445 days doesn't work. We need to become effective. Now what we have is we have 3 to 5 years arbitration process, mostly ad hoc, and then you have to go to the court, and then you have to sit there for years. So what it is doing is that this problem is what is really making things very difficult for the commercial world to litigate in India, and they are taking. If you see, I heard the statement that India should become the hub for global arbitration. Today, SIAC, Singapore, Indian parties are the third largest user of that arbitration. We have not been able to even make the domestic arbitration stay here in India because of not able to support institutions. So therefore, I think in my view, first we should think about is making a hub for domestic arbitration. And therefore what we require is strong institutions which can work on policy, work on cost, work on quality output and reasoned orders. And that is the most important thing for us to maintain that people can stay in India. I think apart from that, I thought that there are few more important, and since Jasmeet Singh is here, I want to use this opportunity. Really,
Mohit will have to.
Yes, two, but this is very important. If you actually think about it today, we heard about the word litigation fatigue in India. We heard about that you fight till the end. Why do we do that in India? And that's an important. It's not that Indians litigate for the heck of litigation. In India, you litigate because you make money by litigation. And that's an important part which I want to tell. Because that is what requires amendment to section 73 to 75 of the damages of Indian Contract Act. Today, Indian contract, you can only get damages which not naturally arose. So therefore, if you're delaying it, you're appealing it, there's no damages, virtually. So therefore, unless you get amendment to the Damages Act, people will not frivolously litigate. And people have to pay the cost of litigation, the cost of delay. If you are using somebody else's money, you have to pay the interest cost, which that corporate is using. These are very important part, because that is how it will bring discipline for litigation. Today, I think we can litigate for everything, because it buys your time. And I'll give you at least one maths before I close it, because this is the maths I gave it at National Judicial Academy. I was part of a faculty and I was talking to sitting High Court judges and I said, I'll give you a maths. Why do we litigate in India and why it makes sense to litigate? If you have to pay somebody 100 crore rupees, the World Bank says it takes 4.25 years to litigate at the first level. So any corporate in India, and we have corporates here, it's the cost of capital is 10 to 12%. So you basically have bought 4.25 years of delay, which is 60 crore. So 100 crore, the cost is 60 crore. What have you paid? You have paid few crore rupees to lawyers and litigate the matter. And then at the end of 4 years, you can go and say, you want to settle for 90 crores? He'll get the officer will get a bonus and you will settle. So therefore, the problem in India is lack of institution and lack of damages. And that is the reason why people can litigate and the courts should award damages and cost. And if that is the case, the ecosystem can come there. And with that, I come to an end. Thank you.
Thank you very much, Mohit. So all the case out for damages, 100 crores and whatever works with it. Thank you. Sanjeev Kapoor, a partner in dispute resolution at Khaitan and Company, about 26 years of experience, and the Vice President of the ICC International Court of Arbitration. Celebrated panelist, of course, all over. I've been with him in several panels and discussions. Comes out with the most marvelous of ideas. Sanjeev?
Thank you so much. I'm conscious of the time, and I had a very long lecture, but looking at the time and also most of the issues have been covered my fellow panelists and there are few to go. But most importantly, I understand we are the only persons who are standing between the dinner and the panel, so I'll make it fast. I think many issues has been deliberated, but there's one issue which has been a recurring theme. It was picked up by Justice Jasmeet Singh, followed by Ms. Anand, and also by Mohit. I think this is the issue which essentially is friction between, I would say, concept of party autonomy and court, I would say, supervision. When should the courts intervene? How much should the court intervene? So I think that's really an issue which is being, I think, brought into forefront into the discussions which we are having throughout evening. All over the world, I think judicial supervision is inbuilt into arbitration. I don't know of any system, any judicial system, wherein arbitration is allowed to run amok, for the use of a better word, without any kind of a judicial intervention. I think judicial intervention is something which is very, very crucial and very, very critical. There has to be an oversight by the judiciary. I think the parameters are well defined. There are obviously public policies, beyond the jurisdiction, fraud, corruption, those kind of very limited issues into which obviously the courts can intervene. But in the right kind of cases, it is duty bound for the courts to intervene and set aside the kinds of awards which do not meet that criteria which is mandated by the law itself. The courts obviously are not the rubber stamps. They are not there just to stamp every award. They are required to scrutinize the award, obviously within the limits which are there. I think what the court should refrain is from very creative interpretation of doctrines. Straightforward public policy, I think everybody understands. But when you start being slightly adventurous into interpreting those doctrines, that is where the problem keeps on coming or recurring. But other than that, I think every advanced jurisdiction would have awards which are being set aside. And in the right kind of awards which are not meeting, at the end of the day, the parties are going to a arbitration not because they want the dispute to end. They want a fair resolution of the dispute. They obviously want the right kind of an evidence to be led, right kind of appreciation of the arguments, right kind of a reason they want to come, and then obviously they would be satisfied with that kind of a process, and that's a kind of a process which any developed, mature jurisdiction will want. But arbitration can't be a process wherein arbitrators are given so much of a freedom, wherein these very basic principles of justice delivery are set aside by them. Therefore, these kind of court intervention, according to me, in right kind of cases, is obviously needed in case the faith of litigating people is required to be there in the arbitration process. If people start interfering in the wrong kind of arbitration award, and they kind of think as to what the perception is going to be, and this award is, let's say, basic canons of law were not followed, falls within the strict limits which the legislature has mandated them to interfere and still not interfere. In that particular case, I think that would be a greater disservice to the arbitration than to a service. So obviously every award is not required to be interfered, but a kind of a right kind of messaging to the entire ecosystem of arbitrations, that wherein you are going not to follow the basic principles and doctrines which are established world over, in those cases will interfere. And whatever are the principles on the basis of which an arbitration award is challenged are not principles which, let's say, India has adopted. These are the principles which are coming from UNCITRAL. UNCITRAL allows, in the case of international awards, to be interfered in a domestic system, provided, obviously, the interference is narrow, interference is very calculated, and interference is not adventurous, or I will say too much of interpretative, etc. also, wherein something which was thought not to be a part of a challenge is also made a part of the challenge. And as far as I think legislature is concerned, that and judicial interference is not always something which is impeding the process of arbitration. It's something which is obviously supplanting that. In India, in case in ad hoc arbitrations, we don't have an emergency arbitrator. The recent amendment is indicating that. But if Section 9 was there, many of the arbitrations would have been just paper arbitration, fruitless arbitration, because by the time the arbitration process would have been completed, the protective orders would not have been there. Similarly, Section 27, an arbitral tribunal has got limited powers, obviously, in case they want to gather certain kind of evidences, etc. Court will then step in, and obviously the process of the court will be used. So it's the intervention of the court is not always a bad thing. I think it's also assistive in nature. And wherever legislature thinks that courts are being too interventionist, they try and correct it. We have now emergency arbitrator who is coming in. They are wanting a concept of arbitral tribunal, wherein instead of a Section 34, you might opt for an arbitral tribunal also. So I think those are the kind of systems which are being built in. But every award which is set aside is not needed to be criticized. Some judgments are required to be applauded because they are obviously inspiring the confidence of the general public in the process of arbitration, and people will go to an arbitration process knowing well that if the arbitrators are stepping out of line and passing awards which are not in consonance with the principles of challenge which has been enshrined, then obviously they would be questioned and their awards would be set aside. Thank you. That's all.
Thank you very much. Sanjeev, I think we've seen the pendulum swing in the world of excessive interference in awards to limited interference in awards to a balanced, mixed approach, the mixed economy kind of approach. But so the pendulum will keep evolving and we'll continue to do the same. Ganesh Chandru is our next speaker. And Ganesh, of course, has had the distinction of being at one of the best bodies, as we say, SIAC, the Deputy Registrar there, a council there. And he's had wide practice in arbitration. So welcome, Ganesh.
Thank you. It's good to be a standing counsel always. If you're not good and thrown out, you become outstanding counsel. So just following Mr. Saraf's footsteps, good to, always when honorable judge is there, it's good to stand and speak. You get more power. I have a whip from the moderator of time of about 5 minutes. So initially I was planning to talk about, there's so much talk about institutional arbitration. And but why is it that parties are hesitant? Why is it not successful in India? Before going into that, move a step backward. Think, why do parties want to have arbitration in the first place? I think we need to ponder on that as an alternative to the regular court system. I'll just start with a small anecdote. There was this party, a client, who was faced with a contract and there was some dispute resolution clause, so this company legal counsel wanted to consult a top lawyer. He goes to a lawyer's office in Delhi, maybe Robin's office. So he goes and sees the office. It's so swanky, full of glass and superb furniture. Looking at that, the client is worried. So the first question the client asks this lawyer is, what's your fees? How much do you charge? So that's the first question he asks the lawyer. The lawyer says, 3 questions, 1 lakh rupees. The client is shocked. Second question he asks is, don't you think this is exorbitant? The lawyer says, that could be the case, but just tell me what your third question is. This, ladies and gentlemen, is the perception of the clients today when it comes to dispute resolution. And I think Mr. Khaitan rightly said about litigation being expensive in India. And the whole purpose of having this alternate dispute resolution mechanism, be it arbitration or mediation, is to take off, number one, the burden from the court system, which in our country there's a lot of backlog, which we all know about. And also, very importantly, that when it comes to arbitration, you not only have legally trained people, but also people from the industry who can either sit as arbitrators or testify as experts before the arbitral tribunal. With all this and so much talk about institutional arbitration in India, why has it not actually taken off? I think there was a lot of talk about China having more than 300 arbitral institutions. In fact, if you go to China and look at an arbitral institution, even in a second-tier city, you'll be amazed with the kind of facilities they have. That's because by law, they only recognize institutional arbitration. There's no concept of arbitration, ad hoc arbitration in China. But in India, with so much of history of legislative history of arbitration, why are people hesitant or why they do not opt for institutional arbitration? First, I think is the lack of awareness. I think most lawyers also, I don't think unless they're practicing in this area of law, they don't know about institutional arbitration. I'm not talking about Delhi and other major metropolitans. I'm talking about the legal community as a whole in the country. So I think the first thing that is to be done to promote institutional arbitration is to create awareness. And the second important thing is, even if parties are aware about institutions, they hesitate because they do not know who the arbitrator is going to be, because the institution is going to appoint. People always say, whatever said and done, if the court appoints the arbitrator, we feel safe about it. And there is some sanctity to the process. But I think for that, the first training of arbitrators and mediators is extremely important. And in that aspect, I think ICA has been doing a fantastic job. In fact, today, there was a 3-day course that has been started, training program for arbitration, and I'm involved in the training program. And I can tell you that when the participants introduce themselves, there are delegates from more than 15 states attending this training program in Delhi today, tomorrow, and day after. So training of arbitrators is extremely important. If you increase trained arbitrators, and if institutional arbitration is going to be a promising alternative to your ad hoc scenario, which is going almost 90% of the arbitration in India is ad hoc. More importantly, institutions should build confidence in the users. Arbitral institution doesn't mean just having a hearing facility. So people say, yeah, I have 2 rooms. That's not an arbitral institution. That's providing facilities. what the arbitral institution does is to administer arbitration. So you also need training for the secretariat of people. How do you administer arbitrations? Mainly, the financial aspect. It's not very good for you to go and deal directly with money matters with the person who is going to be sitting on an ad hoc arbitration. You don't have a choice. Therefore, if all these small pointers are followed, I'm sure there are so many others, and I unfortunately don't have much time to deal with that. I think creating awareness, training of people to administer arbitration, I think definitely institutional arbitration will be a success in India. And the ICA and other institutions as well are doing a great job, and it just has to increase. And it was told the ICA is now 60 years old, right? 60 years old in South India. When a person turns 60, they have a celebration called Sashtyabda Purti, which means, person turns, it's almost like a wedding party that they throw. So it's really it's an opportune moment in the Delhi arbitration weekend. ICA's 60th year, it's a Sashtyabda Purti, and hopefully we all catch up. It's a very good turnout on dinner, and also hopefully some Angrezi, over some Angrezi. Thank you.
हिंदी में समझा रहे हैं अंग्रेजी को. Thank you very much, Ganesh. He's now a part-time member of the IIAC also, talking about institutional arbitration. We now have Mayank Singh Thakur talking about another aspect which we haven't so far delved in delay and dispute resolution and quantum expert. I think he stands alone as a standalone feature in this discussion, though I'll have to ask you, Mayank, to confine it to about 5 minutes. Thank you.
Thank you so much, Ms. Anand. And as you said, I have to stand alone, so I decided to stand. So, good evening, everybody. I'm the only delay and quantum expert in this panel of outstanding lawyers. So, I'll be blunt. Lawyers argue rights, and we, the experts, prove realities. So, basically, idea is that if we quantify early, definitely we are in a position to resolve a dispute early. And I mean to resolve the dispute, not create or make it more complicated. So I'll just cover a few points, and I'll try to stick to the timeline I've been given. I don't want to do my own delay analysis. So my first point is, experts first, not the last. Basically, please bring experts before pleadings. So on day 0, basically, what do? I frame 3 questions. What actually shifted the critical path? How much the critical path is shifted? And because of this, who will pay how much to who? So basically, these 3 questions are framed prior to the pleadings, and if I'm in a position to answer these questions in my pleadings, the case becomes simple and easy to resolve. My second point is technical triage. Basically, we are here to save time and cost in ADR. So basically, I have to issue a 1-page map which shows the chain of causation. So what caused the delay? Then, beyond that, I go for the two-tab model, where I will explain window by window the delays that has been caused and the concurrency flags in. Concurrency is a very important factor. In the second tab, I'm talking about the quantum, quantities, rates, disruptions, and so on. The third thing an expert would help in doing is converting policy momentum into outcomes. So basically what happens? We are clearly pushing for a resilient arbitration mediation ecosystem, but where is the gap? The gap is execution. So what experts do, help make this policy real by making narrative into measurables. Then, but in mediation, why do you need numbers? Yes, you need numbers. Because I give mediators a credible ranges of what impacted the time, what are the cost to complete, what are the disruption coefficients, and so on. So what do I do for that? I do a E&E, early neutral evaluation. That is, within 34 or 45 days, in a quick time, I give a focused dossier. Now, what do I do in that dossier? Top 50 documents, native files. Half a day Q&A with the parties, and then I give a 5-7 pages non-binding note which ranges from one to another options which help the settlement. Third thing I would want to advocate here is hot tubbing. We have been talking about institutional arbitration, so lot is talked about in institutional arbitrations. Most of the institutions, CAC, ICC and so on, have concept of hot tubbing. How does hot tubbing help? The two experts basically sit and argue in front of the tribunal. Now, the things which are agreed is fair enough, easy for everybody. Only the argument happens on the disagreements between the experts. Now, that argument is heard by the mediators or the tribunal, and which helps them to come to a decision. For complex issues, definitely, we always propose a tribunal appointed expert. I have been tribunal appointed expert at times, and the credibility of tribunal appointed expert is always more, but then the argument, the other side expertise is missing. So we generally propose that for very complex disputes. Government PSUs generally are at high stakes, and we have seen government PSUs not very much involving experts. So basically, if an expert is involved in PSU high stake disputes, what do we get? We get a better case management, we get numbers on the table and values, basically, which helps tribunal and mediation to reach legitimate conclusion. Now, the learned lawyers of the panel have talked about interim emergency reliefs. So how does an expert will help in interim emergency relief? We believe that at interim stages, urgency must be evidenced, not asserted. So basically, we help in providing those evidences to the urgency. Now, most important thing, causation and concurrency. What happens if you change method of analysis, the result changes. So if experts are involved right from the beginning and there is a joint statement, basically experts agree both of us are going to use the same method of assessment or same method of analysis. This helps a lot to reaching to this conclusion using same method. They might have different conclusions because they have agreements and disagreements. But since the method is same, it is very easy for the tribunal or the decision makers to come to a conclusion which path taken in the particular method is better. Now, definitely I'm not a legal expert. We have heard a lot about awards being challenged and scrutinized by judiciary. We have seen that awards which are written using experts' opinion by both the parties have survived this scrutiny. And I have been part of such an award where Honorable Delhi High Court has upheld the arbitration award in a matter TKTR versus NHAI, where the expert evidence was of course given by Meeson. Then usage of AI. Of course, lot of AI tools are available, lot of AI platforms are available. So we as experts and our client generally use various AI platforms. In fact, Meeson has its own AI platform where we use scenario based valuations and try to bring up the basic optimistic and conservative figures, which basically these options help parties to understand that where we are and whether it is worth taking it to a dispute for arbitration or mediation. Then, yes, of course, we have heard everybody who was talking about institutional arbitration. So let's make this repeatable. And I propose an ICC curated practice where the experts and panels are accredited, joint statement templates are given, hot tubbing agendas are given, and mediation quant sheets are given. So if by standardizing and institutionalizing things, it definitely helps everybody to come to a standard practice and come to a results which basically are fairer and help to deliver the justice.
Thank you, Mayank. We'll have to go forward. I think.
Yeah. So my just closing remarks. So bringing experts from day zero helps everybody. And thank you so much. You have been fantastic audience. I have part of fantastic panel, and it was great to speak in the same premises where you have been cross-examined first time in your life. Thank you so much.
I think that's the best statement in favor of ICA and the institutions that run the whole processes. We now have the last speaker of the day, Professor Pankaj Chaudhary. In fact, he comes from our Faculty of Law, which is the principal premier institution in addition to ICA. So Pankaj is now the assistant professor and has had a leading international exposure in law as well as general global life. So thank you very much, Pankaj, with you.
So being the last, I think the tapestry between the dinner and I think the program is me. So I have to finish it very quick. So the more has been and much has been said about, for our topic about the ADR. But I want to start because I am an academician here and I have practiced law under ma'am, and when I started the law and I became a professor 15 years back, 10 years back in front of ma'am. So I would love to say, because when I was starting teaching, so I came to her and I asked her a very simple thing: what is the basics? When I'm going to teach in CLC and I've studied in CLC, so what is the basic difference between these two? So she said, when you study this, you just keep quiet like that audience. But when you teach, you have to study more about what questions may be asked to you as a teacher. So when I started teaching second year, this Arbitration and Conciliation Act, and I was giving the lectures, and I started, being with what has been already said with the dais, how beautiful, what is the future of arbitration and conciliation, negotiations, mediations. And one gentleman, had raised the question and said, why this is ADR? Why this is alternate? Why it cannot be parallel dispute resolution? So what we are discussing here today is also, when we're talking about alternate dispute resolution, we are already taking a step back and taking it as already an alternate. So having the Justice Jasmeet sir has said, what the special courts we need? What are the special, maybe the mechanism, time strain do we need? Why Hong Kong, Singapore arbitration is better than us, even for like what we have discussed. For the Indian disputes, commercial disputes, people are going to Singapore and Hong Kong. For his efficiency and neutrality, for his judicial restraint, what we have discussed, for the time-bound implementation of enforcement of the orders. So these are the basics that we have to even think about what we have today discussed. And also strengthening as the Sir said, strengthening the institutional. This is the basics, I think I would say, that can lead arbitration and conciliation, and what we have just enacted a lot in the Mediation Act can do something for the justice. Because, every society is judged not by its disputes, but by how it resolves disputes. So this is the basic that we need to always remember, that how we are resolving disputes time efficiently with the enforcement implementation. So this is, I think, the basics, and I think I will not take much time, and thank you so much.
I think the professor has started very well and led the way on. I think just one statement I wanted to make to close the day. We've discussed various aspects. One structured business dispute resolution process. Maybe we need to just organize a little more, as we said, at the pre-litigation or pre-starting of business stage. We need to factor in this in our own configurations, so that whether it's alternative, primary, parallel, or otherwise, we resort even lesser to dispute resolution methods, and we are able to resolve it at the first outset. In particular, I'll mention one more: resolving the drafting of the arbitration clause. And I leave you, ladies and gentlemen, with this thought. Thank you very much for being such a great audience. The dinner is out, and we hope to have all of you join us. Thank you, Justice Jasmeet Singh, particularly for your participation with us today. So good night for the time being, and we join on for dinner. Yes. Of course.
On behalf of all of us, we extend our gratitude to each of the distinguished panelists for sharing their valuable expertise and perspectives. While the session concludes, the deliberations continue beyond. We now warmly welcome you all to join us for the dinner. Thank you.
Thank you.
जब वो आर्बिट्रेटर जाते तो वही पता नहीं क्या लिख देते हैं
India के country में you have the publication of awards. That's the only way. Publication of awards.
आई थिंक आपको ब्लैक लिस्टिंग भी होना चाहिए क्योंकि ये आर्बिट्रेटर हो गया इसके जो दो तीन सेट साइड हो गए दो तीन सेट साइड हो गए
How are you?
I'm good, how are you?
Well done.